consider another important factor in a contract is consideration. The term consideration is defined like this: when at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises do or abstain from doing something, such an act or abstinence or promise is called consideration for the promise. That is to say, consideration is doing or not doing of something which the promiser desires to do or not do. Another aspect is consideration must be at the desire of the promiser. Consideration may move from the promisee or any other person. Consideration may be past, present or future. Consideration need not be adequate, but it should be real. Now, let us consider the important legal rules regarding consideration. The first important aspect is consideration must move at the desire of the promiser. Consideration must be offered by the promisee or the third party, but it should be at the desire or the request of the promiser. An act done at the desire of a third party is not a valid consideration. Second one, consideration forms a promisee or any other person. Consideration may be proceeded from the promisee or even by a stranger. In India, consideration may proceed from promisee or any other person who need not be a party to the contract. That is, there can be a stranger to a consideration but not a stranger to a contract. It is very important. You can see a stranger in a consideration, but in a contract the stranger cannot sue, which we are going to discuss about it in your future sessions. Another important aspect of consideration is executed or executory consideration. The consideration which consists in the performance of an act is said to be executed when it consists in a promise. It is said to be executory. The promise by one party may be the consideration for act by some other party and vice versa. Another important aspect of consideration is consideration may be past, consideration may be present, or consideration may be future. In the event of service being rendered in a part at the request or the desire of the promiser, the subsequent promise is regarded as admission that past consideration was not gracious. Next one, adequacy of consideration. Consideration need not be of any particular value. It need not be appropriately of equal value with the promise for which it is exchanged, but it must be something which the law would regard as having some value. For example, A agrees voluntarily to sell his motorcycle for 2000 to B. It is a valid contract despite the inadequacy of consideration. One more important aspect is an agreement to which the consent of the promiser is freely given is not void merely because the consideration is inadequate. Next one, performance of what one is legally bound to perform cannot be called as consideration. The performance of an act by a person who is legally bound to perform the same cannot be considered for a contract. Hence, a promise to pay money to a witness is void. An agreement by a client to pay to his counsel after the latter has been engaged a certain sum over and above the fees in the event of success of the case would be void since it is without consideration. But where a person promises to do more than what he is legally bound to do so, such a promise, provided it is not opposed to public policy, is a good consideration. Next one. Consideration must be real and not illusory. Consideration must be real and must also be and must not be illusory. It must be something to which the law attaches some value. For example, a man promises to discover treasure by magic. This transaction can be said to be void as it is illusory. Now, let us move on to the another important area, that is issued by a third party on an agreement. Though under the Indian Contract Act, the consideration for an agreement may proceed from a third party, but unfortunately the third party cannot sue on agreement. The reason is only a person who is a party to a contract can sue on it. But a stranger to consideration is valid and it is different from stranger to a contract as it is void, which means contract by a person who is not a party to a contract is void. The aforesaid rule states that stranger to a contract cannot sue is known as an important principle, that is doctrine of privity of contract. But it is, however, subject to certain exceptions. In other words, even a stranger to contract may enforce a claim in the following cases. Let us check up one by one. The first one is in case of trust. You know there are three parties. One is the creator of trust, the trustee, and the third party is the beneficiaries. A beneficiary can enforce his right under the trust though he was not a party to the contract between the settler of the trust or the creator and the trustees. Second one, in case of family settlement. If the terms of the settlement are reduced into writing, the member of family who originally had not been parties to the settlement may enforce the agreement. Example, a partition agreement among the father and the sons, but the mother, even though is not a party, can claim her maintenance. Third one, in case of certain marriage contracts. The same principle as stated above, a female member can enforce a provision for marriage expenses made on the partition of joint Hindu family. For example, a sister can claim from the father and her brothers in case of her marriage expenses. Next one, in case of assignment of a contract. When the benefit under a contract has been assigned, the assignee can enforce the contract. Example, nomination by the depositor or fixed deposit in any bank. The nominee is not a party. Only the depositor and bank are the parties. But the nominee can enforce the contract. Next one. In case of an estoppel or acknowledgement. Example, assume Mr. L gave to M rupees 2000 to be given to Mr. N, and Mr. M informs N that he is holding the money for him, but afterwards Mr. M refuses to pay the money to Mr. N, who will be entitled to recover the same from the former. Then the last but one. In case of covenant running with the land, the person who purchases the land with notice that owner of the land is bound by certain duties affecting the land, the covenant affecting the land may be enforced by the successor of the seller. And the last one is contracts entered into through an agent. The principal can enforce the contract entered by his agent where the agent has acted within the scope of his authority and in the name of the principal. The best example is consignment sales, where the goods are being sold by the consignee even though the owner is consignor, and the buyer or the consignor can claim from the buyer even though he is not a party to the contract. Now, another important area is validity of an agreement without consideration. So far we have seen that an agreement made without consideration is void. In every valid contract, consideration is very important. A contract may only be enforced when an adequate consideration is there. However, Indian Contract Act contains certain exceptions to this rule. The following are the exceptions. Let us consider one by one. First one. Out of natural love and affection, a written and a registered agreement based on natural love and affection between the parties standing in near relationship, that is husband or wife or sons and daughters, to each other is enforceable even without consideration. Example, a husband by registered agreement promised to pay his earnings to his wife, held the agreement though without consideration was valid. Second one, compensation for past voluntarily services. A promise to compensate wholly or in part to a person who has already voluntarily done something for the promiser is enforceable if the following conditions are fulfilled. The services should have been rendered voluntarily. The services must have been rendered for the promiser alone, and the promiser must be in existence at the time when the services are rendered, and the promiser must have intended to compensate the promisee. To illustrate this, let us check up one example. Mr. P finds Mr. Q's purse and give it to him. Mr. Q promises to give Mr. P rupees 1000. That is a valid contract. Next one. Promise to pay a time-barred debt, where a promise in writing signed by the person making it or by his authorized agent is made to pay a debt barred by limitation, it is valid consideration. For example, A is indebted to C 6,000, but the debt is barred by Limitation Act, but A signs a written promise now to pay 5,000 in final settlement of the debt. This is a contract without consideration but still enforceable. Next one, agency. According to the Indian Contract Act, no consideration is necessary to create an agency. Example, in case of establishment of consignment, the consignor appointed consignee without any consideration. Next one, completed gifts. In case of completed gifts, the rule no consideration, no contract does not apply, because there won't be any consideration between the donor and donee. Thus, gifts do not require any consideration. Next one, bailment. No consideration is required to effect the bailment. Of course, bailment may be of two types, with consideration and without consideration. For example, baggage in a cloakroom is one of the examples. Next one, charity. If a promisee undertakes the liability on the promise of the person to contribute to charity, there the contract will be valid. For example, when the people are donating or giving amount as charity to religious institutions or some other institutions, that there doesn't have any need for consideration, but still such a contract will be a valid contract. Now, let us move on to the another important aspect of a contract, that is capacity to contract. As we know that, can any one person be a party to the contract? The answer is no. Now let us consider who are the parties having capacity or who are competent to contract. Let us consider that. Capacity refers to the competence of the parties to make a contract. It is one of the important essential elements to form a valid contract. Then, if such be the case, let us consider who are the people are competent to contract, are the eligible persons. Every person who has attained the age of majority and who is of sound mind and who is not otherwise disqualified from contracting is competent to contract. Only these persons are eligible for a contract. Now, the opposites of these three are, for majority, opposite is minor. Minors are not competent for contract. And the second one is, who are competent means only sound people. Then the opposite is unsound people or unsound mind people are not competent. The third one is, for to form a valid contract, not disqualified. Now we should know who are the people disqualified. Let us consider these people one by one. The first case is with reference to minors. Let us consider that. The law relating to minors agreement or the position of a minor in a contract. Let us check up one by one. First one, a contract made with or by a minor is void ab initio. A minor is not competent to contract and any agreement with or by a minor is void from the beginning. It is well established case, that is Mohri Bibi versus Dharmadas Ghosh. The second aspect is no ratification after attaining majority. Ratification means giving acceptance after it's happening, post-mortem affair. A minor cannot ratify the agreement on attaining majority as the original agreement is void ab initio. Third, a minor can be a beneficiary or can take benefit out of a contract. This is another important aspect of minor. Though a minor is not competent to contract, nothing in the Contract Act prevents him from making the other party bound to a minor. Thus, a promissory note duly executed in favor of a minor is not void, and it can be sued upon by him because he, though incompetent to contract, may yet accept a benefit. That is, a minor cannot become a partner in a partnership firm. However, he may, with the consent of all the partners, be admitted to the benefits of partnership. Fourth one, a minor can always plead minority. A minor can always plead minority and is not stopped to do so even where he has taken any loan or entered into contract by falsely representing that he was major. Fifth one, contract for supply of necessaries. A minor is liable to pay out of his property alone for the necessary supply to him by any other person, but not from his parents or the guardians. Now let us consider a peculiar case, that is contract by guardian, how far enforceable. Though a minor's agreement is void, his guardian can under certain circumstances enter into a valid contract on minor's behalf, but which is within his competence and which is for the benefit of the minor alone will be a valid contract which the minor can enforce. But all contracts made by guardian on behalf of minor are not valid. For instance or example, the guardian of a minor has no power to bind the minor by a contract for the purchase of immovable property, but such can be done under the supervision of a court. And another important aspect is there is no specific performance suit against a minor. A minor cannot be declared as insolvent because nothing can be paid by a minor. No authority has the capacity to sue the minor. A minor can be admitted for the benefits of the partnership, but he cannot be a partner in the partnership firm. A minor can be appointed as an agent, but minor cannot be as a principal. As we have already discussed, minor cannot bind the parent or the guardian. Another important aspect of minor is if any person enters into a contract along with minor as a joint promises, minor is not responsible or liable, whereas the adult will be liable. If any person gives surety for a minor, even though the primary liability is on the minor, the creditor cannot claim from the minor for which the surety alone is responsible. Next, minor can become a shareholder, but he cannot be a shareholder because he is not competent to contract, for which he has to take into consideration the guardian. And minors are not liable for torts, that is civil wrongs. Now, let us move on to the second area, that is persons of unsound mind. A person is said to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to effect upon his interest. Therefore, incompetent or unsound people are not capable of entering into a contract. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. The best example is lunatic. A person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. The best example is a drunkard. The following are the persons of unsound mind. A person who has completely lost his mental faculties of thinking is called idiot. His incapacity is permanent and in no time he is of sound mind. Therefore, an agreement with him is completely void. A person whose mental facilities are disordered due to some mental strain or some other reasons are lunatics. They can enter into contract when they are of sound mind, that is lucid period, that is insane, but not during insane. The third one, a person who is so drunk or intoxicated and incapable of understanding the terms of the agreement. An agreement made during such position is void and they can enter during the lucid periods. Now, let us consider the last, contracts by disqualified persons. Besides minors and persons of unsound mind, there are also other persons who are disqualified from contracting partially or wholly, so that the contracts by such persons are void. Incompetency to contract may arise from political status, corporate status, legal status, etc. The following persons fall under this category. They are foreign sovereigns, ambassadors, alien enemies, corporations, convicts, insolvents, etc.